Welcome everybody to our quarterly education webcast for board and compliance oversight committees in an effort to increase your ongoing compliance awareness that you can use to serve as you, or that you can continue to use as you serve as fiduciary oversight over the compliance function at CHI and its facilities. I'm Michelle Cooper. I'm the Senior Vice President and Corporate Responsibility Officer for CHI at the system level. We're very excited to offer this webcast for your education entitled Effective Compliance Program Measures. Before we get started, I would like to offer the following poem. It is called Let Us Use Our Eyes. Let us use our eyes to see where we have been and set foot on a brand new path, a new day to begin. Let us use our eyes to seek the righteous way, to hold on to our mission and embrace it every day. Let us use our eyes, our minds, our hearts, our souls to forge a future brighter than any thus far told. Let us come together for purposes divine to seek the highest level, bearing fruit upon the vine. And we shall make the effort to join our purpose true, to move us toward the future in everything we do. And to God be the glory for all that we may do and all that we may accomplish. Let this always be true. And if you'll bow your heads, I'll offer the following prayer. Almighty God, you love all people, but have always held a special place for the poor who depend on you for deliverance. Strengthen us by your grace to appreciate the most vulnerable, to serve them, and to learn from them. Through our Lord Jesus Christ, your Son, who lives and reigns with you in the unity of the Holy Spirit, one God forever and ever. Amen. All right, well, today I'm very excited to introduce Holly Stroud and Sheila Roble, who are two of our compliance professionals out in the individual markets. One is based in Northwest and the other in Nebraska. And first, Holly Stroud is an RN who also is certified in compliance and has a BSN. And she has served in her role as Division Corporate Responsibility Officer for CHI's Northwest Division. She joined CHI in 2009 and started her career as a registered nurse. Holly has been very instrumental in continuing to grow and advance the program in Northwest, and we're very excited to have her speaking today. And secondly, I'd like to introduce Sheila Roble, who is the Corporate Responsibility Officer at CHI Health Creighton University Medical Center, Bergen Mercy, and she's also the CHI National Research CRO and has expertise in the research area. She's served in compliance for over 20 years and brings a wealth of information through her experience with being a privacy officer as well as a compliance officer. Sheila has a JD and also a Master's of Business Administration and Personnel Management. So welcome to you both. With that, I'll turn it over to Holly, who is going to begin the presentation and talk about effective compliance program measures. Holly?
Thank you, Michelle. Today's webinar, Effective Compliance Program Measures, a Governance Perspective, we're going to talk about two guidance documents that were released in 2017. Next slide, please. So the objectives of today's webinar are that you can understand some of the program effectiveness guidance that recently has been released by the government, both the Department of Justice and the Office of Inspector General in collaboration with the Healthcare Compliance Association. We'll talk about the regulatory environment and key cases in the headlines, as well as CHI's response to the federal guidance that we're going to review, and then leave you with some key takeaways as board members. Next slide, please. So the guidance that I referenced, both by the Department of Justice and Office of Inspector General, really will be explained by both Sheila and I'm going to talk first about the DOJ's guidance. The principles of federal prosecution of business organizations in the U.S. Attorney's Manual describe specific factors that prosecutors should consider in conducting an investigation of a corporate entity and to determine whether or not to bring charges, negotiate pleas, or other agreements. These factors, commonly known as the Philip factors, include the existence and effectiveness of the corporation's pre-existing compliance program, as well as the organization's remedial efforts to implement an effective compliance program or to improve upon an existing one. This Department of Justice publication includes important topics and sample questions and is intended to provide transparency into how they will evaluate the effectiveness of a company's corporate compliance program. This 119-question guide grew out of the Department of Justice hiring of compliance counsel expert Wei Chen in November of 2015. They also track with the U.S. sentencing guidelines, but don't focus specifically on the healthcare sector the way the OIG compliance guidance documents do. In contrast, the OIG, in conjunction with the Healthcare Compliance Association, issued a resource guide measuring program effectiveness, and it provides guidance for designing and implementing compliance programs and includes over 400 metrics that address the 7 elements of an effective compliance program and lists suggested ways to measure those metrics. Sheila will provide information regarding that latter document later on in the webinar. Next slide, please. The Department of Justice guidelines fulfill a promise made a year earlier by Andrew Wiseman, Chief of the Fraud Section, to make available to the public a list of questions that they may ask a company when assessing the quality of its compliance program. It is the latest in a line of DOJ guidance documents, speeches, and actions that emphasize the importance of corporate compliance programs. The guidance does not indicate that there are any right or wrong answers. Rather, the questions reveal some insight into the section's views on the components of an effective program. The framework is consistent with prior statements by the fraud section on what constitutes an effective program. However, it also provides more granularity with which the DOJ assesses how an organization has implemented their program. There are 11 areas of focus, and depending on the facts of the case and the focus of their investigation, they may rely on some sections more than others. Next slide, please. So let's talk a little bit about what those 11 factors are. The first is analysis and remediation of underlying misconduct. Their focus is on, was the root cause of the issue identified? Were there warning signs within the organization? And what remediation did the organization take? The second factor, senior and middle management, and it's important to note that board oversight is included in this area of focus. There are questions such as, what compliance expertise has been available on the board of directors? Has the board held executive or private sessions with the compliance officer? What types of information have the board examined in their exercise of oversight in the area in which the misconduct occurred? The third factor, autonomy and resources, really focus on the autonomy and independence of the compliance functions, not only at compliance role, but also stature within the organization, experience, and qualifications. Additional questions that may be asked of a board member is, does the compliance officer have direct reporting lines to anyone on the board? How often do they meet with the board? Policies and procedures, pretty self-explanatory. There needs to be the adoption of effective policies and procedures. The caveat, though, is their integration into the operations themselves. So that, too, is evaluated in looking at this factor. The fifth factor, risk assessment, focuses on the processes in place to assess risk and how effective it is at addressing the risks through the compliance program. Training and communication focuses on employee training, as well as management's response to misconduct. Risk-based training is also included to ensure that areas of the organization where higher risks exist, that training is provided specific to individuals working in those areas of higher risk. Next slide, please. The seventh factor, confidential reporting and investigations. This addresses not only the mechanisms for reporting, but seeks to determine if investigations are properly staffed and scoped, including how high up in the organization do the investigative findings extend. Incentives and disciplinary measures. Ask the questions, are there incentives that you are creating that contribute to the inappropriate behavior, even if unintended consequences? And what disciplinary action is taken when wrongdoing is discovered? Continuous improvement, periodic testing, and review is also an important factor within this guidance. Two new areas of focus include third-party management and mergers and acquisitions. Third-party management explores procedures around the engagement, screening, monitoring, and management of third parties based on a risk profile and any attendant red flags, whether the relationship managers are trained on third-party compliance risks, and also test if mechanisms are in place to ensure that work is actually being performed and if the compensation is commensurate with the services being provided. As I mentioned, mergers and acquisitions are also a new focus, and really look at how the compliance function is integrated into the merger and acquisition process. The questions ask, have deals ever been canceled as a part of the compliance evaluation, or if misconduct is discovered after, was proper diligence conducted and follow-up action taken? Next slide, please. So some other themes of note included in this guidance. Historically, you may have heard compliance officers talk about tone at the top. The DOJ has really reframed the tone at the top to the conduct at the top. In other words, has the board and senior leadership set the right tone in their communications across the company, and does their conduct align with that? Are their actions consistent to signaling that ethics and compliance are a top priority and that the company is committed to doing business the right way? Many of the questions are designed to examine the level of involvement by the board of directors and senior leadership, and to assess if the compliance function is autonomous, empowered, and has a line of sight to the board, as well as organization-wide commitment to compliance. Perhaps most importantly, the DOJ has once again reminded us that boards and senior executives need to do more than a once-a-year flyover of their compliance program if they expect the Department of Justice to conclude that their program meets the government's definition of effective. Next slide, please. Now I'd like to walk through a couple of case studies in light of the factors that we've reviewed, the first being incentives and disciplinary measures. The source of this information is an independent directors of the board of Wells Fargo and Company Sales Practices investigative report dated April 10th of 2017. In that report, it was noted that in 2011, Wells Fargo employment attorneys began to recognize sales pressure in the community bank environment as a root cause of gaming cases, and recognized the existence of significant reputational risk to Wells Fargo. The perception existed in the law department that sales integrity issues involved gaming the community bank's incentive programs and was not conduct affecting customers. That led them to understand the need to escalate and more directly manage the sales integrity issues. While sales practices were conveyed to the risk committee and the board in 2014 as noteworthy risk, the information did not highlight or identify the potential consequences of the misconduct that were distinctly legal in nature, specifically a cascade of civil litigation, regulatory action from a host of federal and state agencies, and the resulting serious harm to Wells Fargo's reputation. The decentralized structure of human resources contributed to a lack of visibility into the scope and nature of sales practice problems. You'll note the comment or quote included by the CEO, "I care about outcome, not processes." The board of directors terminated the employment of the community banking senior vice president, Carrie Tolstead, in September of 2016. The CEO retired in October of 2016. Next slide, please. This slide just would like to share a couple of perspectives of nationally recognized individuals who focused and commented on this particular case, both Warren Buffett and Senator Elizabeth Warren. Wells Fargo subsequently shared mitigation actions at their 2017 Investor Day that was held in May of 2017. This presentation was conducted by the Senior Executive Vice President of Community Banking, Mary Mack. During that presentation, she shared that rebuilding trust is critical and stated, "We have taken many decisive steps as we work to build a better community bank, and we have more work underway." She went on to describe for customers that they had increased customer communication, dedicated phone line and commitment website, and improved their issue resolution processes. In regards to team members, they had eliminated product sales goals, launched new compensation plans with strengthened risk emphasis, expanded the Raise Your Hand and ethics line awareness, launched significant change management work streams, and were embracing a whole new model. In regards to external parties, they added monthly disclosure of customer activity, continued involvement in their communities, reaching out to elected officials, and communicating with regulators frequently. Improved internal controls included strengthening the risk framework by centralizing core functions like human resources and risk, implementing organizational changes and hiring new leadership, and continuing investment in increased supervision, oversight, controls, and monitoring. Wells Fargo actually created a rebuilding trust department. She also reported that Wells Fargo had created a new Office of Ethics, Oversight, and Integrity to house many of the groups responsible for issue research and escalation. This group is tasked with ensuring a consistent process for identifying, assessing, investigating, correcting, and reporting on practices that do not align with Wells Fargo's expectations for high ethical standards and excellence in management. Ensuring Wells Fargo had a retaliation-free workplace was also a huge priority to ensure employees felt safe escalating concerns and that they had the confidence that those concerns would be thoroughly looked into and the appropriate actions taken. Next slide, please. I'd also like to talk about another case study related to the healthcare industry, and specifically focus on the factor of mergers and acquisitions. The headline reads that the SEC charges former IT executive with Foreign Corrupt Practices Act violations. Former employer not charged due to cooperation with SEC in landmark decision. So in this particular event, Harris Corporation was a publicly traded company headquartered in Melbourne, Florida, and is an international communications and IT company that provides service in 125 countries. CareFX Corporation was acquired by Harris in April of 2011. Prior to acquisition, CareFX was a privately held corporation based in Arizona. In December of 2011, Harris Corporation dissolved CareFX as a separate, wholly owned business entity and consolidated CareFX books and records into its financial statements. Junping Zhang, we'll call him Ping, was CareFX's president and CEO. And after the acquisition, he became the Harris Corporation's vice president of technology. From April of 2011 through April of 2012, Ping gave gifts to Chinese government officials at Chinese state-owned hospitals and regional departments of health to obtain or retain business in the amount of between $200 to $1 million. Ping improperly recorded the bogus expenses as legitimate sales expenses or consulting fees, and as a result, their true nature would not be disclosed to Harris. Ping did not disclose the bribery scheme to Harris during the pre-acquisition due diligence. Ping purchased replacements for stolen laptops, cell phones, and cameras for the director of the Zhongnang Hospital of Wuhan University. Ping funded vacation travel and entertainment expenses for other high-level staff at the hospital. Ping also purchased expensive meals for government officials responsible for awarding contracts to CareFX. In total, CareFX made between $200,000 and $1 million in improper gifts to Chinese government officials between April of 2011 and April of 2012. Those improper payments were then consolidated into the Harris Corporation's financial statements. However, their internal auditors at Harris Corporation identified the potential improper payments only a few months after the acquisition. An investigation ensued, led by outside counsel. Suspicions were confirmed, and Harris self-reported its findings to the SEC and to the Department of Justice. And in that press release, the SEC indicated that it did not bring charges against Harris Corp, taking into the consideration that the company's efforts at self-policing led to the discovery of the misconduct shortly after the acquisition. There was prompt self-reporting, there was thorough remediation, and exemplary cooperation with the SEC. Next slide, please. Attorney General Jeff Sessions conducted a presentation at the Ethics and Compliance Initiative annual conference on April 24th of 2017 on the importance of strong compliance programs to prevent and detect wrongdoing. He stressed the importance of building strong cultures of compliance within the company to deter illegal and unethical conduct. He reiterated that the Department of Justice will continue to reward effective compliance programs and better understand compliance efforts. Attorney General Sessions also made it clear that the DOJ remains committed to enforcing all laws regarding corporate misconduct and fraud. He echoed the Yates memo guidance that the DOJ will continue to emphasize the importance of holding individuals accountable for corporate misconduct. When making charging decisions, the Department of Justice will continue to take into account whether companies have good compliance programs, whether they cooperate and self-disclose their wrongdoing, and whether they take suitable steps to remediate problems. As you may be aware, there have been some changes in staffing since that time. Sally Yates, author of the Yates memo that focused on individual culpability for corporate wrongdoing in order to settle, was fired in 2017. Wei Chen, who authored the DOJ evaluation of corporate compliance programs, resigned from her position as DOJ Compliance Counsel effective Friday, June 23rd of 2017, and later published a LinkedIn article in July regarding why she resigned. Quote, she was trying to hold companies to standards that the current administration is not living up to, and it was creating cognitive dissonance that she could not overcome. Also in 2017, Walter Schaub, director of the Office of Government Ethics, announced his resignation. I will note, though, that not long after those resignations, the Department of Justice restructured the healthcare corporate fraud strike force from 5 full-time attorneys to only 2, both of whom are splitting their time in the strike force with other duties. And now I'm going to turn it over to Sheila Wrobel to talk about the second recently released guidance. Sheila?
Thank you, Holly. As Holly mentioned, in January of this year, the Office of the Inspector General and the Healthcare Compliance Association convened a roundtable meeting with 40 healthcare compliance professionals to develop a framework for measuring the effectiveness of compliance programs. The group was divided into 4 teams of 10, and each team created metrics for 2 of the elements of an effective compliance program. The intent of the exercise was to develop a large number of ideas for measuring the various elements. Over 400 metrics were developed by this group and compiled into a 52-page guide. The metrics can assist healthcare providers in identifying what and how to measure. However, the guide is not meant as a one-size-fits-all program for self-assessment. The assessment should be based on the organization's particular risk areas, the organization's size, their resources, and industry segment. The OIG recommends organizations select a small number of measures that are most relevant to the organization's current needs. The OIG stated it does not intend to use the guide as an enforcement tool, penalizing organizations that do not implement all of the metrics. For many years, the DOJ and OIG have encouraged healthcare programs to develop effective compliance programs, but whether a program is effective has been very subjective. This guide provides more objective measures. Next slide. The CHI Corporate Responsibility Program is structured on the original 7 elements of an effective compliance program and also includes the 8th element added by the OIG Hospital Supplemental Guidance in 2005. This 8th element is conducting an assessment of the program's effectiveness. This 8th element is an assessment of how well the other 7 elements have been implemented. The elements have been applied in a consistent manner across all CHI facilities. The annual risk assessment provides valuable information to focus our auditing and monitoring efforts. Next slide. In September 2014, Deloitte conducted an assessment of the maturity of the CHI Corporate Responsibility Program, evaluating the first 7 elements. Each element was assessed for maturity and placed in one of 3 stages. The lowest level is titled Unstructured Reactive for elements in the development mode. This would be in a red or orange color. The middle level is Evolving for elements in the development and implementation mode. This is the green color. The highest level in blue is Proactive Optimized for elements in the implementation mode and deemed sustainable, indicating the program meets and exceeds expectations of leading industry practice and government regulators. 6 of the 7 elements were evaluated as being proactive and optimized. Element 6, Internal Monitoring and Auditing, was assessed as evolving. Deloitte recommended enhancing data analytics and monitoring tools to further improve this element. The CRP program has incorporated use of business intelligence data to create more sophisticated monitoring tools since 2014. The CRP program has further matured in the last 3 years since this Deloitte assessment was conducted. Next slide. To reiterate what Holly said, while the DOJ and OIG guidance were published within a few months of one another, and both cover compliance program effectiveness, there is no indication that DOJ and OIG coordinated with one another in producing the guidance. The DOJ guidance is for internal use in prosecuting corporate criminal matters and applies across different industries. It focuses more retrospectively on the specific criminal conduct being investigated. The OIG HCCA guide was produced as a tool for healthcare organizations to use as a reference tool only, with more robust and detailed suggestions than the DOJ guidance. Organizations that follow the OIG HCCA guide suggestions should also meet the DOJ guidance. Next slide. Here's a side-by-side comparison of Element 1, Policies and Procedures. You can see the DOJ guidance focuses on whether there are policies and procedures in place and implemented related to the prohibited conduct that is the subject of the criminal prosecution. The broader DOJ categories are included in the OIG HCCA metrics. The OIG HCCA metrics have 12 metrics under what to measure, containing over 70 metrics on how to measure. For example, how accessible are the policies and procedures to employees? Are they written in plain language so staff can easily understand them? Are the policies and procedures current? Do employees receive orientation and education on the code of conduct? Is there evidence that policies are enforced? Next slide. As a second side-by-side comparison, as Holly referenced, both documents cover the Board of Directors' fiduciary duty towards compliance. The DOJ guidance asks, what compliance expertise has been available on the Board of Directors? Have the Board of Directors or external auditors held executive or private sessions with compliance and control functions? What types of information have the Board of Directors and senior management examined in their exercise of oversight in the area in which the misconduct occurred? As a board member, have you been made aware of the misconduct? What was your response as a board? 2 of the 7 OIG HCCA elements contain Board of Director guidance. Element 2 on compliance program administration, and Element 4 on communication, education, and training on compliance issues. We will now review the board guidance in each of these areas. Next slide. The OIG guidance provides detailed metrics on the board's obligation for compliance program administration. Our compliance officer in-person reports to the board documented in Audit and Compliance Committee meeting minutes at least quarterly. What information does the compliance reports contain? Does the board understand their responsibilities for compliance oversight? What training materials, newsletters, and other education or update materials have been provided to the board? Does the board not only know what CHI's compliance risks are, but also risk areas throughout the healthcare industry? Has the compliance officer and other leadership brought major compliance issues to the board's attention? Is there timely reporting and resolution of these compliance matters? Does the board demonstrate commitment to the compliance program by approving budgets necessary for effective compliance program implementation? Do the board meeting minutes show active board involvement in discussing compliance issues? Next slide. The second area in the OIG guidance referencing Board of Director fiduciary duties towards the compliance program is Element 4, communication, education, and training. Does the board contain members who have competency in compliance matters? What formal program is in place to orient new board members to the compliance program and their obligations and responsibilities? Has the board and its senior leaders adjusted strategy and operations in response to compliance information received? These OIG metrics offer a more objective methodology to measure program effectiveness. Next slide. The OIG stated it has provided as many suggestions as possible and expects organizations to choose metrics best suited to its needs. Michelle Cooper, CHI System Vice President and CRO, is the co-chair of the American Hospital Association Chief Compliance Officers Roundtable, which is comprised of compliance leaders from 30 major healthcare organizations across the United States. In May 2017, the Roundtable asked Michelle to chair a compliance program effectiveness metrics group to identify and establish consistent effectiveness measures, incorporating control and outcome principles, and develop a maturity model. Once the metrics group completes their work, the full Roundtable will review and approve the proposal, and then the model will be piloted in organizations. The resulting compliance program effectiveness model will not be industry specific, but rather can be used across different industries. This innovative model will provide boards with compliance effectiveness benchmarking data that is not currently available. Next slide. At this spring's annual HCCA Compliance Institute, Department of Health and Human Services Inspector General Levinson remarked that the compliance industry is now 20 years old. He called the OIG HCCA Compliance Effectiveness Guide a game changer and a key piece of guidance in evaluating the architecture of compliance programs. Next slide. The DOJ and OIG guidance is strong evidence that the government is holding boards accountable for ensuring compliance program effectiveness. The government is focused on the autonomy of compliance and the board's responsibility to ensure and preserve this independence. Board members may be interviewed during investigations about their knowledge of the misconduct that has occurred, the actions the board has taken in response to the identified misconduct, and general measures the organization has in place to prevent and detect these and other similar violations. Next slide. Now that you've heard about the DOJ and OIG guidance about compliance effectiveness metrics, including metrics on the board's oversight role, consider questions you might ask your CRO to ensure you have enough information to fulfill your fiduciary duty regarding compliance and assessing whether the compliance program is effective. Does corporate responsibility have adequate tools, resources, and support? What are the organization's highest compliance risks, and what steps are being taken by management to mitigate those risks? Are the necessary corrective actions being taken, including appropriate and timely repayments in response to identified compliance issues? Is there a culture of compliance in the organization where individuals are comfortable raising compliance concerns without fear of retaliation? Next slide. The final takeaway is that proof of an effective compliance program reduces the risk of an organization receiving a corporate integrity agreement as a part of a government settlement. Next slide. The resources that we've discussed today are included at the links on the slide. The DOJ evaluation of corporate compliance programs and the OIG and HCCA Measuring Compliance Program Effectiveness, a resource guide. That concludes our formal presentation. Michelle, do you have some closing comments?
Yeah, and actually, maybe I'd like to pose a question to both of you, just given all of your work in analyzing these documents. There's been a lot of conversation lately about, does an effective compliance program assure you of not receiving a corporate integrity agreement in the event you go forward with a self-disclosure or get into an investigation with the government? And I'd love to hear from both of you what your thoughts are around that, and then I'll also weigh in with my thoughts. So if we want to start with Holly.
I think there's never 100% guarantee that the program is going to serve you as intended, but as we look around the industry and as we look at the experiences we've had within our own organization, I think the government has positively viewed the program, and I think part of that is because we've continually strived to continue to evolve the program and to really try to look at things from the government's perspective, and I think that has really helped us.
I agree. It doesn't prevent receiving a corporate integrity agreement, but it greatly reduces the probability that a CIA would be received, and the government does want to incentivize good behavior and compliance.
Great. My thought is I kind of feel the same. One thing that we've had just in my affiliation with the American Hospital Association Compliance Officers Group, we've had a lot of dialogue around this, and there's a lot of different opinions, especially since I think the government, as far back as 13 years ago, stated that they were going to come out with some concrete effectiveness measures, to where organizations could really assess how they were doing from an effectiveness perspective. And that's really never come to fruition, which is one of the reasons why the American Hospital Association Compliance Officer Group is really working on developing them themselves. But there's a lot of concern that maybe the reason for that and why the government has not come out and said, these are the steps you need to take in putting a compliance program together is because it's so complicated. There's a lot of varying factors, such as size of the organization, services being provided by that organization, resourcing constraints, the line of business that people are in. And I think the government's really never been able to settle on here is how we're going to judge you. And I know with these two resources that we talked about today, they're trying to help us get there, but sometimes it's overwhelming. So I think CHI has always taken the approach, and we've had a lot of dialogue just at the national level at our Audit and Compliance Committee around, what can we do to ensure that we're doing the best we can from a compliance perspective, recognizing that there's also a cost-benefit analysis that has to go into that. But how can we structure our program to be as fail-safe as we possibly can? And so one thing takeaway for people listening to this webcast is to know that we are constantly dialoguing at the national level as well as at the market level around what steps can we take to put a program in place that would meet what we believe the standards of the government would be. And as all we can do is really the best, that we can do in the hopes that what we do put in place will help withstand. Because I think one of the things, and we've done other webcasts, several other webcasts talking about how highly regulated healthcare is, and there are so many different rules and regulations that have to be followed. And, there does come a time when you can only devote so many more resources to auditing, to monitoring, to building internal controls and those type of things to help prevent getting a CIA. But I think CHI really looks at that globally and, make sure that we're putting resources where we believe it's most effective from a risk perspective, and also making sure that we provide things like this webcast for our board and committee members so that when they're acting in their fiduciary role, they have some information and some guidance that can help them ask the right questions. And I know we put some of those questions up for you to think about, and I would just encourage anybody listening to this webcast, when you get a report from the compliance officer at the market and you have a question about something that's being reported, or you do not believe you're getting enough information about, a particular investigation or a compliance activity, to speak up and have an active voice, because we are really there to make sure that the organization is in the best compliance position it can possibly be in. And also, we're there to help ensure that we are providing you with adequate resources and education in order to carry out your fiduciary responsibility. So I don't know if anybody has any other closing thoughts or questions before we wrap up this session.
Michelle, this is Susan. One of the things I was thinking about as Holly and Sheila were talking, is, what prompted the government to all of a sudden develop these resources. And many of us recall, probably it's been 10 years ago, where the government did come out and they were going to pilot a program on how to assess an organization's compliance program. And apparently there was work underway, but we've never heard anything about it. And then it was kind of silent. And but what CHI did is we did implement a kind of a program on how we assess our program. So at least we were proactive in that respect. But it is kind of interesting that the DOJ and OIG now have come out with these resources.
Yeah, I think
it is. Oh, go ahead, Sheila.
The government's message is that each organization needs to own their own compliance program, understanding their risks and how they may shift over time, and then to mitigate those risks.
Yeah. Well, and I think the advantage of CHI being proactive, and we've implemented a compliance checklist that our individual market CEOs sign off on each year, attesting to whether or not they believe their program's effective. We've got several dashboards and metrics that we use to measure how effective our program is. We've had those for a long time, and those have actually proved to be very beneficial for us when we're sitting down and having negotiations with the government. And knock on wood, but thus far, even though we've had some fairly significant settlements and investigations with the government, we have not received a system-wide corporate integrity agreement. And I think that speaks very highly to our board and audit committee oversight within the markets and their support for an ongoing initiative to continue to improve and advance the compliance program. So I think all that just fully supports us continuing to be the best compliance program that we can possibly be, given, the cost-benefit analysis and the risk analysis that we have to perform each year, because compliance is costly and monitoring and auditing is costly. So we really, I think with data analytics and many of the things that we've been presented with over the last few years have really helped us to advance that program and to really look at the more risky areas, I guess is the best way to say it. Relationships with physicians, relationships with vendors, protection of protected health information, ensuring that our quality standards are acceptable from a medical necessity and documentation standpoint. So there's just a lot of tools and resources that we now have available to us that we didn't have 10 or 15 years ago. And I think a lot of that has been spurred by the government's ongoing monitoring, but also I think organizations have been very proactive in trying to really improve and assess their compliance program over the years. So a lot of good is coming out of this. And I think the government issuing these documents in the last year is just a testament to the fact that they really do believe there's important work being done by organizations in ramping up their compliance programs. And I think these were just affirmations of their support for that, to help keep healthcare costs down in the long run. Any other closing thoughts, comments before we wrap up? Okay, well, thank you, Holly and Sheila, for this presentation. And if anybody has any questions associated with anything that was presented today, please reach out to your market corporate responsibility officer, or feel free to email me, Michelle Cooper, 2 L's, and Michelle at catholichealth.net. And thank you so much for listening to this webcast, and we hope you learned something new today. Have a great week. Thank you.